Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this case, in this session, we are going to discuss a beautiful case law on Section 167, Clause 2 CRPC. Simply, we can call it as default bail. Honorable Supreme Court of India stated that default bail can be granted and you need not strictly follow the Ritu Chhabria's judgment, which was delivered on April 26th of 2023 by two judges bench. The matter is under consideration. Actually, the matter is posted to May 12th. It may, because holidays have come, it may take some more time. Anyway, better to understand that Ritu Chhabria judgment need not be followed in all cases. Before that, let us discuss what is this 167 clause 2 CRPC. So already I told you it is relating to the default bail 167 clause 2. Let me read out the provision first. Right, the following. So if the period of 60 days or 90 days, you may be knowing, if the period of 60 days or 90 days, within this period, if the charge sheet is not filed, the accused has got a right to get the so-called default bail. Simply to say 90 days where the offense is with the death, 60 days where the investigation relates to any other offense. So if the period is within the period, if the investigation is not completed and the people did not file the charge sheet, as he got right to get a bail. But what the people will do, they will do some, they will give some charge sheet in the name of a loosely knitted charge sheet. They will file, the police will file, and later they will file additional supplementary charge sheets. All these things, whether they can be allowed or not, different judgments are there on this particular topic. Right. So now, present case, Directorate of Enforcement versus Manpreet Singh Talwar in SLP criminal 5724 by 2023 dated 1/5/2023. Alright, so in this Ritu Chhabria's case, we have discussed what is 167. Now what is this Ritu Chhabria? Ritu Chhabria, she is the wife of Sanjay Chhabria, who is one of the directors of Yes Bank, who has been become bankrupt. He was arrested on 420, prevention of corruption and so many things, and he was not given bail on the condition, on the ground that the charge sheet was filed. But the charge sheet was a loosely knitted charge sheet, or the charge sheet did not contain all the relevant documents. So in such a case, two judges bench, Justice Krishna Murari and C.T. Ravikumar, on April 6, 2023, they stated that yes, he can get bail if the police purposefully file the so-called charge sheet without any documents. But please remember, very recently, in the case of Jasbir Singh, 2023, Jasbir Singh case, they stated that the Supreme Court held that when once a charge sheet is filed, yes, definitely you can call it a charge sheet, whether it is containing all the documents or not. These are two conflicting judgments. జాగ్రత్తగా ఉంది. రితు చబ్రియా కేసులో కావాలని ఏదైనా చార్జ్ షీట్ పేరుకి నామకే వాస్తే చార్జ్ షీట్ వేసినా వాడికి బెయిల్ ఇవ్వవచ్చును. కానీ జస్బీర్ సింగ్ కేసులో చార్జ్ షీట్ అంటే చార్జ్ షీటే, అది ఎలా పూర్తిగా మెటీరియల్ ఉందా లేదా, ఇవాళ కదా రేపేస్తారు, మెటీరియల్ లేదా డాక్యుమెంట్స్ లేవు, రిమార్క్ చేస్తే మనం తిరిగేస్తారు కదా, చార్జ్ షీట్ పెట్టినట్టే కదా, చార్జ్ షీట్ పెట్టినంత మాత్రం బెయిల్ ఇవ్వాలని ఏమిటి అనేది రెండు కాన్ఫ్లిక్టింగ్ జడ్జ్మెంట్స్ వచ్చినాయి. సో దీని మీద ఎందుకంటే యాక్చువల్లీ ఎన్ఫోర్స్మెంట్ డైరెక్టరేట్ దే హ్యావ్ అప్రోచ్డ్ ది సుప్రీం కోర్ట్ విత్ రీకాల్ పిటిషన్. ఈవెన్ అవర్ తుషార్ మేహతా సొలిసిటర్ జనరల్, he also stated that the government is feeling very difficulty. చార్జ్ షీట్ వేసిన తర్వాత కూడా మీరు బెయిల్ ఇస్తే ఎట్లా, రీకాల్ చేయండి అంటే ఆల్రెడీ ముకుల్ రోహత్కి సార్ సైడ్ నో యూ కెనాట్ ఆస్క్ ఫర్ రీకాల్, యూ హ్యావ్ టు గో ఫర్ రివ్యూ. రీకాల్ ఏంటిది అక్కడ కొత్త మాట అని చెప్పి అదర్ సైడ్ అడ్వకేట్ కూడా అంటం జరిగింది. వాట్ ఎవర్ ద మ్యాటర్ ఇస్ పోస్టెడ్ టు May 12th. But here, in the meantime, Supreme Court stated that so-called default bail can be granted. Normally, bail is the personal discretion of the judge. Yesterday already I discussed you the case of where anticipated bail was not granted by the High Court to an IPS officer by name Aditya Kumar. But Supreme Court, yes, no coercive action should be taken against him. Like that, it depends on the personal discretion of the judge. Right. So, different judgments are there. I will just inform you the judgments. Please remember, a right to bail is an indefeasible right under Article 21 of the Constitution of India. So, default bail comes 60 or 90 days, already I discussed. In this case, please remember, number one case, Ajpal versus State of Rajasthan, 2018. In this case, the charge sheet filed by the so-called unauthorized IO not allowed, bail given. Unauthorized IO cannot file the charge sheet. No doubt, according to 173 CRPC, after the completion of investigation, the police officer has to file the final report. Should be filed by authorized officer, not by an authorized person. Second case, yes, Hari versus State. Yes, Hari versus State, 2020. So, no relaxation even in COVID time. 90 days period should be, you should file the charge sheet within 90 days or 60 days. So, the so-called, why all these things? Better, there are interpretation students also, I want to tell them. Why 15 days? Why 15 days of remand? Whenever a person is produced before the magistrate, he should give him to judicial custody for 14 days or 15 days. Then the charge sheet will be filed within 60 days or 90 days. Why all these things? If you go back to the so-called 41st report of the Law Commission, then only you will understand why this period of 15 days. So normally the investigation should be completed within 24 hours, which is not at all possible in most of the cases. So the investigation should be given minimum fortnight time. For that purpose, 15 days. And important cases, you have to file the charge sheet 60 days. Where death sentence is there, 90 days. So go through 41st Law Commission, then you will understand what is interpretation. Interpretation is nothing but understanding the legal intention or legislative intent. For that purpose, please go through the 41st Law Commission report. And now another case, Uday Mohanlal Acharya versus State of Maharashtra. And very recently I have been telling you Satinder Kumar case, very famous case. Satinder Kumar Antil versus CBI, very recent 2022, where yes, the default bail can be given if the police do not file the charge sheet within the fixed time. So different judgments I have noted, I have told you also. So don't be satisfied with the spelling of the judgments. Go through them, read them, or you can read the summary and understand it. Beautiful cases on section 167, clause 2 CRPC. Right, with this I am concluding. Thank you very much.